So yeah, Cambridge Dictionary as well defines it as defines nuisance as to cause trouble or to annoy other people. But as you know, friendly annoyance, would not amount to the kind of nuisance that we are concerned about here. So under law, the nuisance has specific meaning. So so it would be anything done, okay, anything, okay, act or omission, okay, done to hurt or annoyance to the done to the hurt or annoyance of lands, tenements, or hereditaments of another, not amounting to trespass. Okay, so we have not discussed trespass yet. So how would we distinguish between these two? So just for the sake of your own knowledge, okay, trespass is essentially interference with the possession, okay, right of possession of a particular land, okay, property. Uh, Nuisance would be basically harm or another sort of injury which is, uh, you know, done. It could also be with respect to, with respect to the possession, but the difference is this, that in case of nuisance you have to show the damage that has been done, whereas in case of trespass the damage is, proving the damage is not necessary, okay, it's not needed. So how did we define nuisance? So it's anything done to hurt or cause annoyance to the lands, okay, tenements. Okay, tenements means if you are one of the tenants, okay, not owner, or what you have inherited. Okay, so it's essentially land or other property. Okay, that does not amount to trespass. Okay, so nuisance can be of two different kinds. Okay, one is public nuisance and the other one is private nuisance. Now, public nuisance is considered as an offense. Okay, so it is an act or omission, okay, that causes common injury. Okay, no one is, I mean, everyone suffers in common. Okay, so that would be a case of public nuisance. Now, the problem with what happens is that in case of public nuisance, uh, there is no cause of action for individuals. Okay, for individuals, the reason is this, that okay, if the same is allowed, then there'll be many such actions in the court of law. That will be problematic. So if someone commits something that leads to public nuisance, and the thousand different people institute a suit in the court, then just imagine how difficult it would be to redress all such grievances as a form of civil action. Mm. Imagine if damages were to be provide, if this person were to make made to pay damages to all these different claimants. That's unthinkable. So instead, what the law does is law treats public nuisance as a kind of offense, okay, rather than tort. So IPC 268 defines public nuisance. It says a person is guilty of a public nuisance who does any act or is guilty of an illegal omission which causes any common injury. Okay, not just to one individual specifically, to everyone generally. Danger or annoyance to the public or to the people in general who dwell or occupy property in the vicinity. So it does not have to be equal danger to everyone, okay, within the country. People who live nearby, okay, which must necessarily cause injury, obstruction, danger, or annoyance to persons who may have occasion to use any public right. Okay, a common nuisance is not excused on the ground that it causes some convenience or advantage. Okay, it does not matter if your act causes some convenience or advantage. Okay, if it causes inconvenience, then obviously it's a public nuisance. Then you have committed an offense under IPC 268. Now, for examples, it's you can easily understand. So someone stops the car right in the middle of the road, okay, and then everyone else is affected as a result. Okay, so you see that those who had to pass, okay, through that road were obstructed. Okay, so everyone who would pass, who want to pass, through that road will be obstructed. Okay, so this would be a nuisance, which is of public in nature. So that would be a case of public nuisance. But would there be any situation when private, right of action is allowed? Okay, private action is allowed, even when the particular, act or omission amounts to a public nuisance. Well, that is also allowed. Okay, if the nuisance, okay, that said public nuisance causes someone a particular injury. Okay, so the unless it is a particular injury, so you have suffered an injury as a result of that public nuisance, but this is particular in nature. Okay, and such an injury must be direct, not consequential. Okay, it's directly resulted from that particular public nuisance. Okay, not a consequential one. And the injury has to be substantial. It cannot be momentary, fleeting. Okay, it has to be substantial. Okay, in that situation, uh, in that situation, law might, provide you some remedy. So I hope that this is, quite clear to you. We have one case. Just a second. So uh, we have a case in which something of this sort had happened. Okay, it's by the name Benjamin versus Store. Okay, so in this particular case, S, a particular person, S, for the purpose of his business, kept horses, okay, and vans standing outside B's coffee house all day long. So this, I mean, outside of B's coffee house, but not on B's premises. Okay, so this caused obstruction to the highway. Causing obstruction on the highway, as we have just discussed, would be a case of public nuisance. But the that those horses and vans were also right outside B's coffee house. So B complained that he had suffered spatial damage because those vans obstructed the light to his windows. So he had to incur additional expenses, okay, in keeping his shop uh, lit using gas lights. He also further alleged that the smell of the horses made his premises, okay, made the premises objectionable, and as a result deterred customers from coming. So it was held in this particular case that in the light of this special these facts, okay, it was held that these constituted spatial damage, and that would entitle Mr. B here to maintain a cause of action, okay, as against S. So that's the case. So in general, if it is a public nuisance, that in itself would not allow someone to claim have a private right of action, okay, unless that particular person has suffered particular injury. You see, this particular case, the coffee shop owner has suffered particular injury. And was it direct? Obviously, the horses and the van was parked right in front of his coffee house, so it is direct. And it must be substantial. It was shown that yes, he lost in terms of customers, okay, and also in terms of the gas that he had to expend to keep his shop lit. So the court came to the conclusion that yes, it is a case of spatial injury. So as a result, private action, private right of action was allowed even in case of public nuisance. Now, otherwise, if it is not a case of spatial injury which has been suffered, then it will be a case of public nuisance, and in such case, um, as I told you earlier, it will be difficult if everyone is allowed a right of action. Okay, that will be financially disastrous for the defendant. So in such case, the law considers it as an offense. So in India, under IPC 268, it deals with essentially public nuisance. Now, apart from this, there is also something called private nuisance. So that's what comes generally under the law of tort. Okay, it's a kind of tort. So what is a private nuisance? So we have a definition for that. It is using or authorizing the use of one's property. Okay, so either you use it or you authorize someone else to use your property or of anything under one's control. Okay, so as to affect injuriously an owner or occupier of property by physically injuring his property or by interfering materially with his health, comfort, or convenience. So you can do this by two different ways. Physical injury, okay, to the property, or by interfering with their health, comfort, convenience. So these are the two different ways in which the private nuisance can be committed. So it could be done by you directly, or you could authorize someone else to use your property in a nuisanceable way. Okay. Property which is under affect injuriously the owner of property. Okay, owner or occupier of property. So the other person who suffers need not necessarily be the owner. So if it is a tenant, okay, of a particular piece of property, even the tenant will have a right to bring an action for nuisance. So yes, that's broadly the definition. Okay. So it could happen in two different ways: physical injury to the property, okay, or it could in the form of interfering materially with someone's health, comfort, and convenience. So yes, simple example would be, see, when it is a case of annoyance, okay, interference with someone's health, comfort, convenience would be, for example, pollution, noise, etc. And physical injury would be, for example, you obstruct someone's way, okay, to a particular property. Okay, so that would be case of physical injury to the property. So this constitutes ground for a civil action, okay, for damages. Okay, so if you have suffered, you can claim damages. Okay, but you can also ask for injunction, okay, to prevent that party from committing that particular nuisance, or you can ask for both. So when is one liable for nuisance? Okay, so when you cause it, okay, when the defendant causes the nuisance, the defendant shall be liable. But then you do not necessarily have to directly cause it. Okay, there could be situation where the defendant allows it to arise. Okay, you have a duty to also prevent nuisance. Okay, you do not have to merely cause it yourself. Okay, you also have a duty to prevent. Okay, so if you allow the nuisance to arise, okay, by your neglect of some duty to prevent it, okay, then also you can be liable for nuisance. Okay, and then there are other situations when the nuisance arises without the defendant's own act or default. Okay, but then he omits to remedy it within a reasonable time of when he becomes aware of it or ought to have become aware of it. Okay, so when you did not create it, okay, but you did not do anything to prevent it either or stop it either. Okay, when you have come to know of it, or when you ought to have come to know of it, in those situations, the defendant will be held liable. So as we just saw, it could happen in two different ways. Okay, it could be direct injury to the property, okay, or it could also be in the form of discomfort. Okay, so injury to the property would be sufficient for you to then claim, damages, seek remedy. Okay. So if injury happens, then well, that's something that you have suffered. It's clear. Okay. Then you can claim some remedy. But what about discomfort? Okay, so when it comes to personal discomfort, so for example, you go to the town and usually it's very noisy. There's so many shops. Okay, people are preparing food and all that. So law has to keep all these things in mind. Okay, it depends on the time, the place, the circumstances to find out whether the act amounts to something that is actionable. Okay, so for personal discomfort in itself would not be sufficient. Okay, but then there could be physical discomfort as well. Okay, so in case of physical discomfort, okay, as we have discussed earlier, uh, so what would be the situation in those situations? So in those situations, the act which is complained of must, having special regard to the circumstances and surroundings of the defendant's property. Okay, so these are the things that you have to keep in mind. Where is the act complained of has happened, and at what time has it happened? Okay, so for example, during the day, it is normal for us to expect certain level of noise. Okay, but if the noise persists in the middle of the night, okay, when you are supposed to have sound sleep, okay, then the time matters when the noise arises. Okay, so all these things have to be kept in mind. Okay, so two factors have to be kept in mind. Okay, with regard to the circumstances and surroundings. Okay, where the defendant's property is situated. Those are, if the said act complained of isn't okay, if it is in excess of natural and ordinary course of enjoyment of the property. Okay, so the act which causes the discomfort, okay, is not the natural and ordinary course of enjoyment of the property. Okay, then it can be complained of, or when it materially interferes with the ordinary comfort of human existence. Okay, not just any other a noise. For example, if there's a road by the side of your house, there'll be certain noises. Okay, if there is another, if your house is right, for example, in the heart of the city, hustle and bustle, of the city, then you have to accept that, well, there'll be shops, there'll be certain other things. Okay, that will cause certain kind of discomfort. You have to accept that. Okay, but if it is more than just that, okay, if it materially interferes with the ordinary comfort of human existence, in those situations, then one can be held liable. So time and circumstances are very important. So and the degree to which the interference has happened, those things are to be kept in mind. So with respect to this, we have a case by the name Hunter versus Canary Wharf. Okay, Hunter versus Canary Wharf. So in this particular case, the facts are like this. A large tower was constructed in the Docklands area of East London. It was constructed by Canary Wharf Limited. The tower was 250 meters tall, and its location was very close to, less than 10 kilometers away, to the primary television transmitter of BBC. As a result, the tower was interfered. Okay, the tower interfered with the television reception of a group of residents of a certain locality. So subsequently, the interference was fixed. Okay, by the installation of relay towers. However, the claim was made. Okay, a claim was made. The claim in the case argued private nuisance. Okay, private nuisance for the period during which the interference was felt. Okay, until it was fixed. During that period, the interference that was faced with regard to that, a case of private nuisance was argued. So what was many claims had come. Okay, so what was the issue here? The issue in this particular case was whether the interference with one's television reception amounted to actionable nuisance. So it was held that the interference with one's television reception through the construction of a neighboring structure could not and does not amount to actionable nuisance. Okay, this is something that you have to accept in your life, that if there is a property, one natural way of using that property would be to construct structures. Okay, but it does not mean that those are unregulated. So if you're living in a certain municipal area, there might be certain regulations with respect to what kind of constructions are allowed. But if something is done which is allowed, okay, and then it interferes, with your enjoyment of the property, then that in itself will not lead to any cause of action. So it has to be, as we just discussed, in excess of natural and ordinary course of enjoyment of the property. Okay. So, for example, if in your locality, okay, a residential locality, someone comes up with a chicken farm, okay, and then it's not ordinary. It definitely interferes with your enjoyment of the property, okay, in excess of natural and ordinary course of enjoyment of the property, and it also materially interferes with the ordinary comfort of your existence. So in those situations it will not be allowed. However, in the instant case, it was held that, well, erection of that building in itself did not lead to any cause of action for nuisance. So yes, that's there. Okay, with respect to injury to property, okay, what kind of injury to property would be necessary? So as you know, in case of trespass, if you just enter someone's property without their permission, amounts to a case of trespass. Okay, even if nothing, no injury is suffered, okay, that in itself is sufficient for a cause of action. But in case of injury to property, there has to be a sensible injury, and when there is a sensible injury, that will be sufficient for a cause of action. Okay, so there could be many such examples. Okay, so for example, you have a property. Okay, you have a dwelling house. Okay, someone starts a manufacturing unit adjacent to it, and then there is constant noise and all that. Constant vibration and all those that you feel. Okay, so that's a case of physical injury to your property. Someone opens a drain, okay, sewers, etc. So those will be cases of physical injury to your property. Okay. Now, it does not matter if the nuisance already existed and then you came to that place subsequently. Okay, so even if the nuisance had already existed and then you came subsequently to the place where the nuisance had already existed, that does not mean that you do not have a cause of action. So with respect to this, okay, we have a case, okay, that goes by the name St. Helens Smelting Company versus Tipping. So in this particular case, the claimant was the owner of a large country house with over 1,000 acres of land. This this land was close to a copper smelting factory, okay, which had long been in operation. So it was there already for a long time. Now this smelting factory discharged noxious gases as a result of its operation, which were considered to be a normal part of the smelting operation. As a result, the trees on claimant's land were damaged by the fumes. Okay, the claimant here, okay, sued that person for nuisance. Okay, so the issue was that, okay, the question is that this copper smelting factory had already existed before the plaintiff came to that place. So the issue is whether the defendant had acquired a right to carry on the discharge of their fumes as a result of smelting through acquisition for long use. So this is something you will study later. Okay, if you're doing something continuously for a long period of time, okay, you for 20 years for prescription, then you acquire it, a right to do that. Okay, so in this particular case, whether the said person, the said company, okay, say insurance company, had acquired that right or not. Okay, so, and whether that constitutes a defense to the plaintiff's claim of nuisance. Okay, so in this particular case, the court accepted the plaintiff's claim. Okay, and it was held that it was no defense to say that the claimant came to the nuisance. So even if you come subsequently, that would not be reason enough to deny you the remedy. And the defendant could not be said to have acquired a right through prescription to continue to discharge noxious fume. So that's what has been held. So even if you come to the place of nuisance subsequently, that in itself will not be reason to deny you a claim. Okay. Now, with respect to material discomfort, we already discussed that the discomfort, okay, must be, the interference substance has to be material interference, okay, with an ordinary and reasonable standard of comfort, okay. So, and then we discussed that it has to be, considered in the light of the time, place, and circumstances, okay. So, examples of the same would be, so for example, if you have a house, okay, by virtue of some structure, okay, which is erected, it obstructs the light that enters your house, okay, or someone plays loud music adjacent to where you stay, or someone is burning plastics and then causing air pollution or something of that sort. Okay, all these cause you physical discomfort. So you're not complaining of any injury to your property, unlike the previous cases, okay, where the injury was with respect to property. But in this particular case, you were complaining of physical discomfort to you. Okay, so in those situations as well, okay, you have a cause of action. So with respect to this, we have a very important, case by the name Sturgis versus Bridgman. So in this particular case, the claimant was a doctor who moved, his house, okay, and on the premises, he bought and built a shed in his garden, okay. So he has to, carry out his private practice. Now, this property was adjacent to a, confectioner's, place. Okay, the confectioner would make sweets, and in the process, the process involved grinding his pestle, okay, and mortar, and that caused nuisance to the, to the doctor who had created, who had built that shed for practice. Okay. The doctor comes subsequently, okay, as you can see clearly. So whether the doctor had a claim or not. So the issue was whether the doctor could claim loss of amenity when he had moved to the nuisance or not. The doctor had moved to the nuisance, and whether the character of the area and locality as a residential area meant that there was a nuisance. So it was held that there was a nuisance, and the fact that the doctor had moved to the nuisance in itself was no defense to the nuisance itself. So yes, that's another example of a case of nuisance. Now, in case of nuisance, who can sue? I mean, who is the person who can sue? So, is it the owner of the property who sues or anyone else? Okay. So, with respect to this, you have to keep in mind that if the nuisance is temporary in character, if it does not, cause some permanent damage, lasting damage to the property, okay, if it is temporary in character, then the person who's occupying the property or the premises, okay, are the only ones who can bring this, cause of action, okay, bring this suit, okay. The reason is that only the person who suffers should be able to bring the suit. So, however, if the harm, okay, if the damage is of permanent character, okay, or if it if it inflicts a lasting damage, then even the landlord, okay, or the person ultimately to whom the property goes back, the reversioner, okay, would also be able to, can also sue. Now, who is liable to be sued? Okay, so this is again quite easily understood. The person who actually creates the nuisance would be the one who would be sued. Okay, so the idea is that action is to be brought against the hand that commits the injury, or against the owner for whom the act was done. So quite often the owner might authorize, if you remember we discussed, someone else to do something which leads to some kind of nuisance. In such case, the person, who authorizes, okay, so against the owner for whom the act was done, okay, will be sued. Uh, Now, what remedy do you have if a nuisance happens? Okay, so if a nuisance happens, the first remedy that you have is of that of abatement. So, for example, someone's, so now the nuisance could happen through act or through omission. So, if it is a case of act, okay, nuisance through act, okay, then you as an individual have the right to abate the act causing the nuisance. Okay, so you can remove, okay, the that which causes the nuisance. Okay, uh, so yeah, so abatement means removal of a nuisance by the party injured without recourse to legal proceedings. I mean, however, it has to be peaceable. Okay, it cannot be forceful. Okay, it should not. The process of removing the nuisance should not cause danger to life or limb. Okay, in that situation, you can do that. But if it involves entering someone's property in order to remove the nuisance, then you have to provide notice to that other person. However, you are to keep in mind that law does not encourage you to do this on your own. Okay, only in limited situation. But in case of omission, okay, in case of omission, you cannot you cannot as an individual compel someone to do something. Okay, you have to go by the legal way. But in case of omission, also you can abate it. So, for example, if your neighbors have a tree and the branches of the tree hangs over your property, in such case, you are very much within your right to remove those branches, okay, on your own. So it was, the nuisance happened as a result of omission, because they did not cut those, control those branches. Okay, so you have a right, you are very much within your right to remove those branches. Okay, which was essentially a nuisance for you. Now, apart from this, you can also claim damages. Okay, and there are certain rules with respect to how much you can claim that you will discuss later on. But one thing that you need to understand is that the nuisance causes some decrease, some diminution in the saleable value of the property. Okay, as a consequence, due to the nuisance. Okay, so the damages will be to that extent. The plaintiff, however, must prove some spatial damage. Okay, spatial damage has to be proved by the principle. Okay, the principle is to be applied in cases of nuisance. Okay, it's not whether the defendant is using his property reasonably or otherwise, but simply that it injures his neighbor. Okay, does not matter the purpose for which the defendant was using. Okay, if it injures the neighbor, then you are very much within your right to seek damages. Okay, so yes, so it will be based on how much diminution of value has happened due to the nuisance. Okay, the third one is that, okay, yes, damages can be sought, but then you may also want to prevent the party from doing the act that led to the nuisance in the first place. So you can also seek injunction, that prohibits the person from doing that which causes nuisance. But at the same time, this does not mean that these are exclusive. So if you claim damages, you can also ask for injunction, okay, as a preventive remedy. Okay, if you ask for injunction, that does not mean that you will not be entitled to damages for the loss that you have suffered. So these are the remedies which are available to you in case of nuisance. So that's it. Tomorrow we will take up some other topics for this subject. Thank you.